Indian news ma wakɔ aba assign de ba wɔn kasa fidie so bio. Na maka trust before anything else na just our share na ebiem nso kwa na wo subscribe to your channel no. What's the fa political news there? Never governance. We catch you sa pan input of ma yet. Na pan yet of ma yet there. Ani na nsɛm foforɔ bi nso asan esi. Benim sɛ wo de nsɛm ade bɛn nyina na ya na ya wote na ya wohwe na ya wofɛ nso so. Nti no nsɛm foforɔ bi asi a India news yɛn nso so pan yɛ tɔɔfo mi baabi yɛ ti nyinaa akyi no yɛn nsa atumi aka bi na yɛaso nso atumi ate saa nsɛm bi. Yɛn tie nsɛm mmra sisi a na mpanimfoɔ mpo sɛ kakum no yɛgye no kɔkɔɔ anum. Deɛ ba before that no subscribe to your channel no. Sa bɛka all other news ɛfa politics wɔn de deɛ wɔpɛ sɛ wɔtie no ɛho. Yɛtie ba yɛbɛn baabi a susu nso pɛ so wɔde bɔde wɔn fa na deɛ asie biara no nso fa comment nso to aseɛ na yɛn kenkan mfama wo deɛ yɛhwɛ de nneɛma ɛkɔ. Yɛn tie nsɛm mmra sisi a wotie no fa comment to aseɛ ba a yɛn fa nkyɛmu no nso nto aso. Yɛn tie mmra.
My name is Elton Brob. We're going to introduce legislation, in fact, a legislative instrument that will establish new rules for the removal of Supreme Court and other Superior Court judges. The announcement was made on the floor of Parliament by the Majority Leader, Mahama Yariga, amid an ongoing process to remove the Chief Justice Gertrude Tokono. That process, currently underway, has drawn sharp criticism from the opposition MPP, which claims it is a deliberate attempt by the NDC to oust the Chief Justice unfairly. We'll hear from Mahama Yariga shortly on what government plans are to protect this particular office. But first, here is Deputy Minority Leader Patricia Piaget, who has described the move as shameful, an effort to undermine judicial and stuck the Supreme Court with NDC loyalists.
Vicious attempt by the presidency to undermine judicial independence have reached dangerous proportions. The nation watched in disbelief as the executive launched brazen efforts to remove the Chief Justice of the Republic. An assault not merely on one officer holder, but on the very sanctity of the judicial branch. At the same time, the president is seeking to pack the Supreme Court with loyalists. 7 nominations in one swoop, clearly designed to bind the hands of the Judicial Council and tilt the highest court in the land towards executive interest. Equally troubling is the identity of the legal practitioners leading this crusade. While the right to counsel is sacrosanct and every citizen is entitled to legal representation of their choosing, it is profoundly disquieting that spearheading the campaign against the Chief Justice are individuals publicly known to have represented or are still representing both the President and the Speaker of Parliament in active legal matters.
All right, so this is the opening remarks from the Parliament, is back in the House today to begin government business. Now, the Parliamentary Affairs correspondent, Kwaku Asante, joins me on via Zoom. So, Kwaku, I'm curious to know the Majority Leader's explanation for these new rules that government is seeking to introduce to Parliament.
Like a bombshell that the Majority Leader did drop, because the Constitution provides in Article 146 specifically the rules that will lead to the removal of a Chief Justice or Justices of the Superior Court. And so in his opening remarks, and one would be open to accepting that that was sort of a response to Patricia Piaget's claims about the NDC seeking to pack the court with NDC loyalists. He dropped that shell that the Attorney General is expected to lay legislative instrument, constitutional instrument, or that will enact new rules that will guide the removal of judges from the Superior Court. As you know, Article 146 introduces specifically what the rules will be, and the courts have, on a number of occasions, also interpreted what those rules are about. And so he does not say specifically whether this will come by way of a constitutional amendment, because Article 146 is an entrenched provision, and if you want to change any part of it, it would have to go through a referendum for that change to become law. But listen to the majority leader himself in his own words, explaining what he says is the commitment of the president to ensure that the judiciary is not actually
subsidiary legislation. They include the corporate insolvency and restructuring regulations, the Court of Appeal rules, Economic and Organized Crime Office operations regulations, Economic and Organized Crime Office terms and conditions of service regulations, High Court Civil Procedure Amendment rules, interpretation regulations, judicial service terms and conditions of service regulations, legal aid commission regulations, Supreme Court rules, and very significantly, removal from office of justices of the Supreme Court rules. The President, John Dramani Mahama, is determined to fast-track legislative reforms to strengthen our institutions of governance and further entrench our democracy. The President is committed to legislative clarity with transparency when it comes to the constitutional mechanics of the removal of justices of the superior courts.
So, I wonder whether there's already been reaction to this proposal by Mahama Yarega to the floor.
And some of them, as we hear from the video, they shout A and other things. Some of them were taken aback, they were a bit surprised about this. But because he was the last leader on his feet to speak, there was no rebuttal really from the minority front bench or any person for that matter from the minority side, except that later on the speaker himself did make his opening remarks where he spoke generally about issues having to do with parliament and national issues. He did not touch on this removal of superior court judges. But this is certainly something that we'll be hearing something from the minority on, perhaps in the days ahead or even today, because it will be interesting to see how exactly are these rules fashioned and how will they sit in tandem with the Supreme Court. Will this merely be legislative instruments, LIs, CIs, and other subsidiary legislations, which will be subservient to the Constitution of the Republic, or the government intends to amend the Constitution to change the process that has been outlined in Article 146 of the Constitution? So yes, officially no response yet from the minority or any person for that matter in Parliament, but this is something that will certainly draw reaction. Except that earlier today, I did speak to Vincent Ekwase, for Member of Parliament for Old Trafford, who did go to the Supreme Court a couple of weeks back, challenging the processes to remove the Chief Justice. His judgment is out, that 80-page judgment that has simply been in circulation over the last few days. He did say that he was going to study that ruling and decide what exactly he would do, whether he will seek review or not. He says he's still consulting. But he was reacting to my question about the new affidavits that have been deposed by the suspended Chief Justice about some mental ordeal that she said the committee investigating the matter is subjecting her to. And she said, and he, I should say, said that it is clear from all that is happening and from the affidavits deposed to by the Chief Justice that they are setting underhand dealing to simply get Madam Tokoro out of the way, and she's not going to get a fair trial from that five-member committee chaired by Justice Gabriel Scott Foreman.
I don't see why a Chief Justice will appear before a committee and he will be searched like a petty criminal. Meanwhile, the lawyers who are representing the petitioners are not searched. The lawyers who are representing the petitioners are given the free will to be able to take in their phones, their laptops. The indication is that they have some information on it. But the Chief Justice does not have the right and authority to bring information that is on her laptop or her phone to the committee. It cannot be a fair procedure. It cannot be a fair treatment.
So your understanding of all that is that there's clearly some attempt to gag or to unfairly remove the Chief Justice, or what do you see from that?
I have maintained right from the beginning of this process that the process is fraught with unfairness. There are a lot of procedural improprieties, and it looks as if somebody has made up his mind that by hook or crook, the Chief Justice will have to be removed.
course, Vincent Akwasafa will join us pretty soon as we explore the latest twist to this, ongoing process to probe the Chief Justice for allegation of misconduct. But before I let you go, just a matter that is not entirely related to this Chief Justice, but I heard Mahama Yariga make the point on the floor in his opening remarks that the Speaker should, in the matter relating to some comments Parliament deemed, derogatory relating to the former late President John Rawlings, Mahama Yariga made the point that all backbenchers around the space that this, comment came from should be held responsible and made to appear before the Privileges Committee. Did the Speaker rule on that?
We know that it was last meeting that comments were made. That comment, the death of the murder comment. We recall that the Speaker of Parliament gave the said member of Parliament, whose identity will be not known yet, 1 week to reveal himself. And as of now, 2 months on, no one has come forward to say that he was the one. You heard there the majority leader rightly say, like you said rightly, that they are very incensed about that comment, and they're not going to let it go. They are insisting that if the member of Parliament who made those comments do not come, they believe the comment came from a certain direction, and that group of people must all be held responsible by being sent to the Privileges Committee of Parliament to answer questions. The Speaker of Parliament, while he was making his comments, also did take aim at that and said that Parliament was still investigating the matter, and that for him personally, it is disappointing that the member of Parliament has not come forward, and also that no one in Parliament seemed to know who made that comment. He says it's very disappointing that MPs can claim that they do not know who made those comments, and that he, as head of the legislature, will continue to investigate this matter to the very end. He says, and in fact, back in the point Mahama Yariga made, that the comments were made, and in fact, he zoomed into 3 members of Parliament, he said, sat at a particular place in the minority benches. He actually said that when those comments were made, the minority leader, Alexander Penny-Markin, who at the time was on his feet, let turn his head to look at the third member of Parliament. And so he's surprised that neither members on the minority side or even the majority side who are facing these MPs have been able to come forward to name specific persons who must be investigated for this. But he says he's committed to investigating this to the very end.
So it's first day in Parliament, and already so many things to chew on. Kwaku, thank you so much for joining us this afternoon. And of course, this afternoon we are spending so much time on the matter relating to the suspended Chief Justice and matters that are coming out as a result of the ongoing process. Now, Gertrude Tokonu has described the ongoing investigation by the Gabriel Praman-led committee to potentially remove her from office as unjust and a blatant mockery of justice. In a supplementary affidavit filed at the Supreme Court registering support of a motion for an interlocutory injunction, Justice Gertrude Tokonu expressed concern for what she termed persistent violations of her constitutional rights and a sustained assault on judicial independence. The Attorney General, Dominic Ayine, has swiftly rejected all her demands, and we'll share that with you shortly. But first, let me bring you the details of the CJ's affidavit for interlocutory injunction filed at the Supreme Court. So there you have it on your screens, and she's making certain demands. She says, I respectfully seek leave of this honorable court to bring to the court's attention various developments since the filing of the present application, which evidence a complete desecration of my basic constitutional rights to a fair trial, violation of my dignity, and subjection to inhuman and degrading treatment of a kind not meted out to even accuse persons on trial for treason and other offenses against the state. And he says, I was informed by my lawyer, Kwabena Edu Kusi, that the proceedings of the committee set up by the president to inquire into the 3 petitions filed against me had been adjourned to a day after the commencement of our action in this honorable court, that is the 22nd of May, 2025. And then on the 22nd of May, he says, I appeared before the committee together with my lawyers and informed the committee members of the suits I had instituted against the Attorney General and the committee members, in response to which the committee requested to receive copies of the processes filed and adjourned proceedings to the following day, Friday, 23rd May, 2025. And so on the 23rd of May, the day after, She says, notwithstanding receipts of the processes filed in the Supreme Court, including the application for interlocutory injunction, the members of the committee indicated their resolve to proceed with the conduct of the inquiry. And this was so according to, even though I have to date not been told the basis for the determination of a prima facie case against me and the specific allegations in respect of which a prima facie case has been established for me to answer, to enable me determine my legal rights or adequately prepare a defense to the charges against me. She goes on to say that the committee refused to recognize my counsel simply because I was not personally present, and proceeded to fix a subsequent hearing days and make arrangements for the hearing without involving my counsel, even though he was present. The committee, shockingly, according to her, simply refused to recognize the same counsel on whom it has served a hearing notice only a day before. Now, Getutokonu goes on to say that other developments like the denial of access into the hearing room for my husband and children, searches on my body, denial of access to telephone and laptops for myself and my lawyers, even though counsel for petitioners have access to their phones and laptops, and the conduct of the hearing itself in a highly security zone at the premises of the castle also shows a deliberate effort to subject me to mental torture and degrading treatment in violation of my fundamental rights. She says, all Article 146 proceedings, with the exception of the one I am being subjected to, had hitherto been held in judicial facilities, specifically the courts complex. The location of proceedings affecting me to a cordon high security facility boggles the mind. And he said the persistent violation of my constitutional rights show that the whole proceedings initiated against me are a mockery of justice and a ruse to unjustifiably remove me from office as the Chief Justice. And she is praying the court intervention by the grant of an injunction to prevent the assault on judicial independence and protect the security of tenure of the Chief Justice and justices of the Superior Court of the Republic. And so this is what Getutokonu in an affidavit has presented to the court with the hope that she will get a response. Well, the Attorney General, Dominic Anine, has a quick response for the suspended Chief Justice, and a lot of things that the Attorney General has been saying in response to what the Chief Justice Getutokonu in that affidavit presented to the court. And amongst them, the AG says that the in-camera hearing is a constitutional command geared at safeguarding not only the CJ but the entire judiciary. It can therefore not be waived. The AG said there is no basis in law for the two Supreme Court judges to be restrained from participating. And in concluding on this, the AG concludes that the case of injunction has not been made out. And so that's the response to the AG. But the court is yet to sit on this particular matter for us to have a conversation on it. Now it's a good time to bring them some legal brains for their perspective on this matter. Now joining me on phone, of course, privilege as always, to have Mr. Kwaku Ansari, a former director of the Ghana School of Law. Mr. Ansari, good afternoon and always a